And I also saw something about a lion in the courtroom. So please tell me, which of these two things do you think matters most for a trial lawyer?
I would say 100%, telling stories. I think, we have to remember that at the end of the day, the people making the decision are going to be a panel of random jurors that come in with no legal background, don't really understand what's going on half the time. So how do you break things down in layman terms? And, for example, take something that's kind of vanilla, like a contract dispute, and make it actually interesting and bring the individuals who are suing or being sued to life so that the jury can really get to know who they are, what they're about, and choose a side, the good side or the bad side.
Or is it possible sometimes they meet in the middle?
Certainly at mediation, at trial, I'm not hoping for a tie or something in the middle. I'm going for the gusto. But at mediation, you're 100% correct.
Well, this has been a common theme that I've heard a lot from trial lawyers is the importance of storytelling. And I assume this also applies to mediation. Do you agree?
100%.
And your audience there is a little different, though. Now you're talking to seasoned adjusters, professional negotiators. How might your story change, if at all, when at mediation?
I think it's important to always take a step back in mediation and put yourself in the other side's shoes. So, for example, I do personal injury and then I also do business contract litigation. So, both mediations and how I prepare and how I tell a story are very different. Obviously, the personal injury, it's very easy to learn about the victim, how they've been injured, how their life has been impacted, and convey that to the other side. Um, in business cases, it's a little different. In the personal injury angle, I understand that adjusters probably may have 3 or 4 mediations in a week. So how do you differentiate your case from all the other cases that they hear about? How do you stand out in their mind and get your case, from the bottom of the pile to the top? And I think one way I do that is to try to be authentic and not necessarily put on a show, but show them that if this case goes to trial, this is what they can expect, the type of performance, the type of explanations, the story that a jury is going to hear. I don't like to leave anything to chance. I don't like to play games or make threats. I like to put it all on the table for them so they fully understand every angle. And trial is always a last resort, if that makes sense.
Sure. So, what you're doing is providing them information and options. Either you can settle with this narrative or take your chances and see what happens at trial.
The one leverage that plaintiffs' lawyers have is that if the adjuster and the attorney for the other side are not going to come to a reasonable settlement, then we believe that if we go before a jury, they're going to give us a lot more money, right? That's the one leverage we have. We can either work this out together or we can use the jury trial process. And the only way to convince an adjuster and an attorney with 20 years of experience who do this every single day is to do the work before you get to mediation. And by that, I mean, take all the depositions, take all the experts' depositions, prepare your client so that when you step into the mediation room, you've already proven to the other side that you're one of those real trial lawyers. You're not one of those lawyers who's looking for a quick settlement and already focusing on the next case. I want the adjuster and my client who's there to believe that this is the only case I have. This is all that matters to me. And I'll take as much time as it takes to get the right result.
We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.